The heirs can still protect their successional right, for as stated in the rationale of the rules on annulment of voidable marriages and declaration of absolute nullity of void marriages, legal separation, and provisional orders, compulsory or intestate heirs can still question the validity of the marriage of the spouses. Not in a proceeding for declaration of nullity, but upon the death of a spouse in a proceeding for the settlement of the estate of the deceased spouse filed in the regular courts. In Portugal versus Beltran, the adverse parties are putative heirs to the estate of the decedent or parties to the special proceedings for its settlement. If the special proceedings are pending, or if there are no special proceedings are pending, or if there are no special proceedings filed, but there is, under the circumstance of the case, a need to file one, then the determination of, among the issues, heirship should be raised and settled in the said special proceedings. In the same case of Portugal versus Beltran, where special proceedings had been instituted but had been finally closed and terminated, however, or if a putative heir has lost the right to have himself declared in the special proceedings as co-heir, and he can no longer ask for its reopening, then an ordinary civil action can be filed for his declaration as heir, in order to bring about the annulment of the partition or distribution or adjudication of a property or properties belonging to the estate of the deceased.
In order for the putative heirs to claim from property of spouses to avoid or illegal marriage, the general rule to pursue the declaration of heirship is only done in a special proceeding for the establishment of a status or a right, as in the cases of Litam, Sulivio, and Gita's cases. In Litam et al. Versus Rivera, 1956, a special proceeding for issuance of letters of administration was instituted. In Sulivio versus Court of Appeals, 1990, the remedy availed of by the putative heir was special proceeding for settlement of the estate of the deceased. And in Gullias versus CFI Judge of Pampanga, 1972, partition and recovery of shares.